Hi, I'm Marty Pritikin, the Dean of Purdue Global Law School, the nation's first fully online law school. Welcome to this latest installment in our Distinguished Speaker webinar series titled Israel and International Law. This is obviously a very timely and very controversial topic. Fortunately, our featured guest today is well qualified to address it. Eugene Kontorovich is a professor at George Mason University's Antonin Scalia Law School and director of its Center for the Middle East and International Law. He's recognized as one of the world's preeminent experts on international law and the Arab-Israeli conflict. He's published dozens of scholarly articles on the topic and has appeared in the Wall Street Journal, New York Times, LA Times, Politico, and numerous other leading publications, as well as on television and radio programs on Fox News, CNN, MSNBC, Al Jazeera, Sky News, BBC, NPR, and more. After graduating from the University of Chicago, he clerked for Judge Richard Posner on the United States Court of Appeals for the Seventh Circuit. He has previously taught at law schools of University of Chicago and Northwestern University, and has been honored with a fellowship at the Institute for Advanced Study at Princeton, among many other awards. Professor Kontorovich, I want to thank you for being here today.
Thank you.
Sorry. Before we get started, I want to point out that I recognize that many people may have very strong opinions about this topic, especially in light of the October 7th massacre and the ensuing war in Gaza. My goal here today is obviously not to discuss personal opinions, but to look at the issues from a legal lens and see what international law has to say about them. So I trust and expect that if members of the audience have questions, they'll pose them in a respectful manner. And depending on the timing and the conversation, I will endeavor to try to weave in a few audience questions into discussion. I must also state that any views discussed during this webinar do not necessarily reflect those of Purdue Global Law School, Purdue University Global, or the Purdue University system. Okay, now, having gotten all that out of the way, let's get to the topic at hand. So first of all, Professor Kontorovich, let's begin at the beginning. Let's talk about the formation of the modern state of Israel and its legitimacy under international law. I was at an AALS conference in January in your hometown of DC, and there was a session on the Israel-Gaza conflict, and there was a professor, actually from BU, where you just spoke yesterday, who called into question the legitimacy of the state of Israel. So from your perspective, from an international law perspective, what is the status of the state of Israel under international law?
So Israel is a state. Israel is a country. It is recognized by something like 160 countries in the world. It's a member of the United Nations. It engages in diplomatic relations with countries, and I think it's not seriously debatable that it is an actual country in the world. There is no international doctrine of legitimacy of countries. Should countries have been created? That is to say, we don't say should Pakistan have been created. Maybe Pakistan had a very traumatic breakup with India. The Indo-Pakistani breakup was very complicated. Should Iraq have been created as Iraq, or should the Kurds? Maybe it's illegitimate because the Kurds didn't get a country. Should Lebanon have been created? Should any country have been created? There is simply no such doctrine in international law. Once a country exists, it exists. And the doctrine of sovereign immunity means all countries have sort of a basic equality. And there are countries that are premised on illiberal principles, like let's say the Kingdom of Saudi Arabia, which is an absolute Islamic monarchy. But it's a country. We don't say, should Saudi Arabia exist? Or the Hashemite Kingdom of Jordan, which is a country that is based, as its name suggests, on the rule by one particular family, the Hashemites, over an entire population of Palestinians. So we don't say, should these countries have been created? Now, in fact, Israel has better international pedigree than almost any country, but I hesitate to say this because I don't want to suggest that there is a need for an international pedigree. Most countries have none, like the United States. Should the United States exist? I don't know. Maybe it shouldn't. Maybe it should be handed over to the Iroquois Confederation or whoever else was here before. But once it exists, it exists. And You cannot undermine its right to defend itself and vindicate the rights of its citizens. Israel, in fact, was created pursuant to an international decision of the League of Nations 100 years ago to create a Jewish national home in this particular section of the former Ottoman Empire. Now, very crucially, it was not just Israel that was created through this process, which we call the process of mandates. Lebanon was created through the exact same process, Syria through the same process. All of those faced objections from minority populations living in the area, whether they be Sunni Muslims in Syria or Druze and Kurds, Sunni Muslims in Lebanon, Druze and Kurds in Syria. We don't go back and say maybe that we should undo those countries. Now, in fact, Jordan itself, the country of Jordan, owes its existence to the same legal document that resulted in the creation of the State of Israel, the Mandate for Palestine. The
Now, if I
mandate
can
for
just stop you there for a second, though, well, and maybe you're about to explain this, but I want to make sure, our audience understands. Mandate seems like a demand, right? I mean, when you hear it in common parlance, that's what you might think of as a mandate. But what we mean by that, right, is in the context of the aftermath of World War I, right, which ended in 1918. So mandates, and you're the expert, so tell me if I'm wrong, but my understanding is a mandate was it was a plan of sort of temporary stewardship with the intention of transferring sovereignty to a local population. Is that correct?
That's correct. And today, it's not an anachronistic thing. As a matter of fact, the mandates were continued in the ones that were not completed were continued into the United Nations period. The United States itself was a mandatory power. That is to say, they administered some of these, what we would call nation building exercises, would probably be the contemporary Indian. And under the UN, they were called trust territories. So the idea is the territory is put in trust to become an independent nation state. So the mandate for Palestine, which was the one that concerns us, Palestine at the time did not refer to an ethnic group. It referred to a territory. And that's the territory that currently contains areas we would now call as Israel, the West Bank, Gaza, and the country of Jordan. That whole area, basically from the Mediterranean to Iraq, was one area called Palestine, and it was to be administered by the British with the eye of creating a Jewish national home, or recreating it, actually said, reconstituting a Jewish national home. Because the League of Nations understood, as many people have forgotten, that Jews were indigenous to this place. One paragraph, I believe it was Article 25 of the mandate said that if, it's not practical to have a Jewish national home in this territory, in this entire territory, it can be split down the middle to create a two-state solution. In other words, an Arab state on the east bank of the Jordan River and a Jewish state on the west bank. And the British immediately did that. And under this League of Nations mandate, they created what was called Transjordan. Transjordan because it was on the other side of the Jordan, Eastern Jordan, which became the Hashemite Kingdom of Jordan. So, in other words, the entire country of Jordan owns its existence to one paragraph of the Mandate for Palestine, which also gave rise to a Jewish national home in the remaining part of the territory. So, if anybody has a problem with the legitimacy of the Mandate for Palestine, they also have a problem with the entire existence of the country of Jordan. I have yet to see on campus protesters, calling for an end to Jordan. Though I'm sure there are people who think that.
Well, so if the original plan was that what was then Transjordan, the eastern half of the British Mandate of Palestine, became the modern country of Jordan, and that was supposed to be the Arab states, why wasn't the remainder of the western portion of the original British Mandate, why didn't that entire territory become the Jewish states?
So the principal answer for that is because the surrounding Arab countries, including at that point Jordan, this was by 1940. This was after World War II. So in the 1930s, Britain put the whole Jewish state thing on hold because of pressure from Arab countries, and in particular, they adopted what you might call they tried to restrict immigration, Jewish immigration, to Palestine. Um, and Then World War II happened. Everybody was busy with World War II. After World War II, Britain ended the mandate, and that area would have become a Jewish state. Israel declared independence, and was immediately invaded by its Arab neighbors. So Jordan, Iraq, Syria, Lebanon, Saudi Arabia, um, Egypt, they all invaded, and their goal was to prevent the creation of a state of Israel, a Jewish state anywhere in that territory, to wipe out the Jewish state that had just been announced on the western half of between the Jordan River and the Mediterranean. They were partially unsuccessful, thus the creation of the state of Israel. But they were partially successful, and they took parts of that territory. In particular, the Gaza Strip was taken by Egypt and occupied by Egypt, and the West Bank, as it came to be known, was taken by Jordan. Indeed, it got its name, the West Bank, by Jordan, which named it that because it was on the west bank of the Jordan. So the reason that entire territory did not immediately become part of the state of Israel, it may have legally become part of Israel, but the reason it did not entirely come under Israeli control was because of the invasion, which managed to take those territories and expel and ethnically cleanse every single Jew from those places.
Well, so how does UN Resolution 181 fit into this story? This was passed in 1947. It was a General Assembly resolution that called for the partition of the territory from British mandated Palestine west of the Jordan into Arab and Jewish states. So how does that factor into this under international law?
So that's a good question. I mean, I think the first thing to ask yourself is oneself is, how do UN General Assembly resolutions factor into the border of countries at all, right? And the answer is they don't, right? The United Nations General Assembly does not have the power to set the borders of countries under the terms of both the League of Nations and the UN Charter, which deals with mandatory territories that remain under the UN. They don't have the power to change the terms of mandates. So what it was is, by 1947, it became clear that the establishment of any Jewish state would be met with invasion, attack, and potentially extermination by the surrounding Arab countries. The UN was trying to avoid that conflict. So they said, hey guys, okay, you know what? Let's not have a fight. Let's split this other half that's left. Let's split that again. And they proposed a split in order to avoid conflict. It was a proposed compromise. So that has the status of any other proposed compromise. If the parties accept it, good. If they don't. Then not. So that compromise was not accepted by the Arab states, who, as I just mentioned, invaded. So it does not have any legal effect, I would say.
Okay, well, and so in terms of the borders, right? I mean, a lot of
Israel
people.
was not created by that UN resolution. Israel was created by declaring independence. The UN did not come to its assistance, and indeed hindered its efforts in the War of Independence by imposing an arms embargo on it. If Israel had lost that war, the UN Resolution 181 would not make it a country. And so it is not a legal aspect of Israel's statehood, I would say.
And so, what about the Arabs who were living in that territory? I mean, one of the most common things that's said is that the Jewish claims for self-determination in that land and the Arab claims are in conflict. I mean, do the Arabs living there not have a right to self-determination as well?
So first of all, there's no right of secession in international law. You can't, that is to say, once a country exists, to break off based on self-determination claims is not a right that international law recognizes. Now, in 1948, when the Jews asserted self-determination claims, the Arabs did not assert self-determination claims. That's a very important historical point. Maybe they should have. Maybe they were poorly led. Maybe they were ill-advised. But that is to say, only one group claimed statehood in the mandatory boundaries, namely Israel. Right? Israel said, we are establishing a state here. Other parties, said we want part of that state, like the surrounding Arab countries said we are going to take parts of this territory, as indeed they proceeded to do. Right. So when Jordan took the territory, they did not establish a Palestinian state, nor were they criticized by the international community for failing to do so. So there is a right to self-determination. The right to self-determination is different from the right to statehood, as evidenced by, for example, the Kurds, the Uyghurs, the Tibetans, and the hundreds of truly genuine ethnic or national groups that do not enjoy their own state despite very badly wanting one. Now, in fact, Palestinians enjoy the right of self-determination, and they enjoy maybe the right of self-determination, multiple times. That is to say, there's a Palestinian self-determination under the Palestinian Authority. The Palestinian Authority is the government of the Palestinians in the West Bank. It reflects, I wouldn't say it reflects their wishes in the sense that it has not stood for election in a long time, but it governs them, and it is not Israel who is in charge of the Palestinian Authority, as evidenced by the fact that the Palestinian Authority does lots of things directly against the interests of Israel, like passing laws, paying money to people who kill Israelis. So that's part of the Palestinian self-government. Gaza is also part of the self-determination of the Palestinian people. Hamas is a government in Gaza. Maybe it won't be the government after the war, but in fact, there is a government there. So the dispute now between Israel and the Palestinians is not about self-determination, which Palestinians have, I think, exercised and enjoyed since the Oslo Accords in the West Bank, and certainly since the pullout of Israel from Gaza. It's over borders. Right? The Palestinians would like to exercise their right of self-determination within larger borders than they currently enjoy it.
Well, so talking about borders, there's a lot of talk about pre-1967 borders and post-1967 borders, right? So since 1967, since the Six-Day War, the prevailing view is that there's been an occupation by Israel of the West Bank and Gaza and the Golan Heights in the north. So is that, as has been claimed, an illegal occupation under international law?
So I would say no. I mean, I can tell you the United States recognizes the Golan Heights as part of Israel. That's the official legal position of the United States. The term illegal occupation is a little bit confusing. Occupation is generally not illegal in itself. America occupied Berlin for over 40 years. These areas is a very big question, and really not well suited for like question and answer. But in short, the borders to which Israel has a sovereign claim. What does occupation mean? Occupation is when you take the territory of another country in wartime. So what happens? Let me ask your viewers this: if Ukraine were to have some kind of miracle and in an amazing 6-day campaign managed to dislodge Russia from Crimea, which Ukraine has not controlled for like a decade.
Right.
Maybe let's say by this time, let's say this happens in 9 years. If in 9 years, Ukraine dislodges Russia from Ukraine, at this point, Ukraine will not have controlled it for 19 years. The people there are not generally wanting Ukrainian control because the ones who are there now are the ones who want Russian control. The ones who want Ukrainian control have largely left for, return to Ukraine, areas under Ukrainian control. Would Ukraine be occupying Crimea? And the answer would be no, even though the people there don't want them. It is within Ukraine's objective international borders. And how are those borders set? Those borders are set by the borders of the previous top-level administrative unit at the moment of Ukrainian independence. In the case of Ukraine, that was the Ukrainian Soviet Socialist Republic, whose borders included Crimea not for any good reason and not because anyone wanted them, not because it was democratic, but because of Soviet imperial border drawing reasons. Similarly, the last top-level administrative unit where Israel is the previously mentioned Mandate for Palestine, which, as we said before, included Gaza and the West Bank. They were not separate areas. The idea of Gaza and West Bank were created in 1948 by the occupation of those areas by Egypt and Jordan. Since in international law, we do not believe that occupation can change borders. Surely the borders created by Jordanian and Egyptian occupation cannot be effective. The last previous legitimate borders are the borders of the League of Nations mandate, which are Israel's borders. Thus, when Israel expelled the Jordanian occupation from the West Bank and the Egyptian occupation from Gaza in 1967, it was not putting those areas under occupation, but it was ending a different foreign occupation and, let's say, liberating or reestablishing control in areas to which it had sovereign claims. But in any case, and even if that wasn't true, as even Jimmy Carter's own State Department legal advisor, Jimmy Carter, no friend of Israel, uh, wrote in 1977 that if Israel were to make peace with Jordan, there would no longer be any possible argument that the West Bank was occupied. Israel made peace with Jordan in 1994.
So again, to ask about how a specific UN resolution factors into this, UN Resolution 242, right, talked about essentially land for peace, if I understand that. So how does that resolution factor into this analysis of the borders?
Say it again.
UN Resolution 242, in the wake of the 6 Days War, my understanding that was a resolution that basically put forth a scheme whereby land would be exchanged for peace. Do I understand this correctly?
So what 242 said in particular was that Israel should have its legitimacy and borders recognized by its surrounding neighbors, which has not yet happened. Lebanon and Syria, Palestinians remain at war with Israel. And that Israel should withdraw from some of the territory, but that it established control over in 1967. And as that resolution was being debated, there had been some proposals to say that Israel should withdraw from all of the territory. And those proposals were defeated because it was considered unreasonable to make Israel withdraw from all of this territory. It would put Israel in, return Israel to the so-called what I believe Abba Eban referred to as the Auschwitz borders that were unsustainable from a security perspective that Israel had from in the brief period between 1948 and 1967, when Israeli towns were subject to constant infiltration and attack in the 8-kilometer, 8-mile wide narrow waste. So
Wait, you're saying the state of Israel is 8 miles wide at its narrowest point?
that is correct. No, not anymore. But yes, before in the so-called 1967 borders, that is correct.
Okay.
Indeed, in the current invasion on October 7th, one of Hamas's objectives has been learned was to cut across from the sort of northern tip of Gaza and connect with the West Bank, which is not a very long trip at all, and thus cut Israel in half. So Israel has withdrawn from almost all of the territory it took in 1967. It withdrew from parts of the Golan Heights. It's withdrawn from parts of the West Bank. It's withdrawn from all of Gaza, and of course, all of the Sinai Peninsula, which was 95% of the territory, and the only part of the territory that had oil reserves. So Israel has withdrawn from territory, but it has not gotten the peace, so much in return.
Okay. And then, well, what was the
In other words, 242 did not make a specific determination of borders. And I have a paper available about this called Resolution 242 Revisited in the Chicago Journal of International Law.
Okay, well, thank you for that. And so what was the immediate response? I mean, I know you're saying UN resolutions aren't binding, but what
I
were,
didn't say that. They can be binding. They're not always binding. And it depends also what they say. So 242 is binding in terms of what it says. What it says is Israel should withdraw from some territory and get some peace. So that's happened.
and so what was the immediate reaction from the Jewish and Arab sides to UN Resolution 242?
The immediate reaction, I think Israel saw it as a generally positive thing. The Arab response was the famous three no's of Khartoum, that the Arab League, Conference of Arab Countries, met and they said no normalization, no peace, no compromise, etc.
Okay.
But
Well,
again, I do think it is a mistake. People like to get involved in the historical details with Israel, and I want to say I'm not sure. It's a useful discussion to have as long as we keep it in the proper perspective. The rights of countries today are not determined by reference to obscure historical arguments, right? That is to say, let's say that I could prove to you there's some country like the United States that did something very evil 50 years ago, bombing with Nagasaki. That does not in any way diminish America's ability to sort of defend itself or protect itself today. If, say, Japan wanted to invade America and in retaliation for some horrible thing America did.
I definitely see that. So let's talk about this issue about refugees. So there's been a lot of talk in the news since the recent war in Gaza about UNRWA, which is, I think, the way you pronounce the UN Relief and Works Agency for Palestinian refugees in the Near East. I think that's the full title. But it's called UNRWA, right? Is that correct?
Yes, the
Okay.
Real Relief Works Agency.
So there was allegations made by Israeli intelligence that that there were actually UNRWA employees who were actually involved in the October 7th Hamas attacks, that there were hundreds of UNRWA employees who were actually part of Hamas, including its military wing. But let me lay some background. So what is UNRWA? How was it formed? When was it formed?
Um, First of all, let me say what UNRWA is not. There is a United Nations agency that deals with refugees from all around the world. Be it Africa, Asia, or Latin America. It's the UN Worldwide Refugee Agency. It's called the United Nations High Commissioner for Refugees, administers a program of aid and rehabilitation to refugees who are refugees under the United Nations Refugee Convention, which is a treaty dealing with refugees worldwide. There is one special exception for that, and that is for refugees, um, Palestinian refugees, as they're called, which have a whole separate definition and an entirely separate agency to deal with them. That agency is UNRWA, and it was established after Israel's War of Independence. Um, and it's different in a few ways. First of all, it's a separate agency. The only, secondly, it has a unique definition of the. So for every other refugee context in the world, and by the way, I say this speaking as a refugee. I have a refugee visa when I came to the United States. Um, the number of refugees in every refugee situation, a refugee situation starts, there's a conflict, people flee, and then the number of refugees goes down over time because they settle down in different places.
Like
Um,
the India-Pakistan partition, for example, right?
exactly, exactly, or any other situation in the world, Burma, wherever you want to say. Um, there's only one situation where the number of refugees grows exponentially over time, and that is the Palestinian situation, because the Palestinian refugees are counted as refugees while they remain in the region, that is to say, in the Middle East, um, under a definition that does not apply to anyone else. Normally, you're a refugee when you flee a place from conflict or persecution. And then once you establish a different residence, you are no longer a refugee. You live where you're living. And certainly your children are not refugees because they never fled anywhere. Fleeing is the definition of being a refugee. Now, in international law, there are no ancestral statuses, right? That is to say, my kids would not be like you can't like pass down being an international law professor. It's not like the British monarchy, right? What you are is not what your kids are. Everyone's their own person. Um, so there's one exception to that also, and that is the status of being a Palestinian refugee, which does not depend on having fled anywhere, like a refugee from, let's say, Burma or North Korea, but depends on being born to someone who had the status, or born to someone who was born to someone who had the status. So, in other words, it is a purely hereditary title now. So, most people who are counted as Palestinian refugees, the overwhelming number, did never fled anywhere. Were not born in Palestine, did not flee. And so they would not be counted anymore as refugees any more than my children would be, simply because I was a refugee. Um, that is a unique status. And what it does is ensure that there is constantly a growing Palestinian refugee population. Surrounding Arab countries have not been particularly good about granting citizenship to the Palestinian population, to essentially keep them from settling it down, to make this a perpetual unresolved issue to assert against Israel. And Palestinians are truly the victims of this, and it's quite tragic. It's very strange. I don't think anyone who calls themselves pro-Palestinian can support the maintenance of this ongoing intergenerational quasi refugee phenomenon.
So, from what I've read or heard, there were approximately 700,000 or so Arabs who were displaced during the Civil War and the Israeli Declaration of Independence and the subsequent attacks. Um, so, in terms of numbers, right? Was that the original population of people classified as refugees, and what's the current number, if you know?
I don't know the current number, but it's in the it's in the many millions now. It's in the many millions.
And so, and I know you're not as focused on the history, right? We're focused on the law, but I mean, from a obviously history and law tied together, how did this come about that there was a separate refugee agency and a separate refugee definition for the Palestinians as opposed to the rest of the world?
It was created by the United Nations General Assembly, and Arab nations wanted to secure two goals. They wanted to not have the Palestinians, who they politically supported, but I think we're not fond of generally, settle down in their countries, and so calling them refugees would allow for giving them giving them this permanent refugee status would be a reason not to give them citizenship. Say, no, 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 we're waiting for them to go back to Palestine. And additionally, it creates a permanent issue of contention with Israel, which is consistent with the rejectionist position of the Arab states in the three no's. But as one studies international law and finds in the context of Israel, there's a lot of unique one-off situations. But as a result of being specific to the context, UNRWA faces a much greater risk of what's called, what we would call agency capture, right? When an agency design regulatory capture, when an agency designed to regulate or provide services is essentially dominated by those whom it's supposed to interact with. Where the United Nations High Commissioner, which deals with like 30 different refugee populations around the world, is not going to be beholden to any one of them.
And so how does the right of return factor into this? Or maybe a better threshold question is, legally, is there a right of return? I've heard it said that I think it's UN Resolution 194, some say enshrines the right of return. What is the claim of right of return, and what is the legal status of that?
Oh my, we're skipping around a lot. Well, it's hard to keep up.
Sorry, yeah, sorry. I mean, I was
again,
I was thinking
these
about
are
the
these are big
refugees, right, and
these are
their
big subjects.
location.
The claim is that at the end of a conflict, refugees have a right of return to their homeland. But again, that only that right, to the extent it exists, only applies to refugees, not those who do not meet the international standard of refugees. Right, the so-called right of return comes from the international the Refugee Convention. But Palestinian refugees are not refugees under that Refugee Convention. They have their own separate definition and status. So I think they're just not, I think there is no such general right in international law, certainly for non-refugees, which is what we're dealing with. Yeah.
But what about Resolution 194? Does that create a Palestinian right
Let
of
me make
return?
a general point. United Nations General Assembly resolutions cannot create rights.
So what is the impact then of that resolution?
No,
It's
again,
essentially
I can't
advisory.
adjust some of these questions, but the United Nations General Assembly is not a legislature, right? They don't have any. The United Nations General Assembly is not like the Congress of the world that they can just make laws for the countries of the world. Obviously, why would the United States choose to be, subject itself to a Congress of a majority of dictatorships? So any General Assembly resolution does not have legal status. It is a political proclamation akin to a one-house resolution of Congress.
But I thought you'd said earlier, well, I think
What
I'm
did I say?
confused, so I apologize. Let me try and clarify, right? So I thought you had said that the UN Resolution 181, which proposed partition of the land, that wasn't binding. I had thought you had said that therefore UN resolutions aren't binding, but then you said, well, they might. It depends on what they say, right? That if they might create rights, they don't establish borders. So are there
UN,
situations?
UN General Assembly resolutions are non-binding.
Oh, you're talking about as opposed to, what is it, the Security Council?
Yeah.
Okay. So let me make sure I got that straight, and to clarify in case I've confused our audience. So what's the distinction between the legal effect of a UN Security Council resolution and a UN General Assembly resolution?
Really big subject, but let me just make it simple.
I
UN
apologize, but no.
General Assembly resolutions are inherently non-binding. The only thing the UN General Assembly has the legal power to do is declare its own, set its own budget. Security Council resolutions can, under Chapter 7, authorize certain measures. They can authorize the use of force, they can authorize economic sanctions, which generally otherwise would not be available to countries.
Okay.
And have a legal effect.
Okay. Thank you for that. Thank you.
But again, I don't want people then to say, oh, you missed that detail or you missed this detail. This would be like 2 days in international law class.
I know, and I'm trying to cover a lot, and I'm jumping around a
No,
lot.
no.
So
So, but maybe try to like ask things that I don't want anyone to say you missed a detail.
I hear you. And please, at any time, feel free to correct me or follow up if I am, missing something important. I know, a little bit, enough to be dangerous, but you're the expert, so I want to make sure we get these things cleared up. Um, well, I did want to transition to the current conflict, but before I did, let me ask you, I mean, is there anything that we've talked about so far in terms of the formation of Israel, the 1967 borders, any of the prior history with the UN that you would like me to follow up on or you'd like to clarify?
No, I thought no. I think it's all reasonably clear. But again, I think the key is when you're looking at international law in Israel, you're not going to learn what the international law is in Israel if you just start asking questions about Israel, right? That is to say, what about this UN resolution? What about that UN? I would actually start from the opposite, right? Place. How do you figure out the borders of countries, right? As a general, not and pretend we're not talking about Israel, right? Pretend we're talking about Ukraine. How do I know what the borders are? Nobody would say, "Oh, look what the United Nations General Assembly said," right? That is not like on the list of how we would go about finding the borders of countries. So before one, in order to prevent an analysis from being, what do I think about like the political history of the Middle East? The legal approach is to first identify rules that are going to apply to various countries, make sure that they apply generally, and then apply them to Israel. So what did the UN say in this year? What did the UN say in that year? Is only interesting if we first have a general principle of the UN creating countries and establishing their borders. Since there is no such general principle, it's not clear why it would be relevant here.
Okay, thank you for that clarification. Okay, so I was going to transition to talking about the war. Let me talk generally. What are the principles of war? Is there a body of international law that talks about whether a war is just or whether the conduct of a war is just?
There's not much of a body of international law about whether a war is just sort of in its inception. There's a basic principle that you're not allowed to use war as an element of your foreign policy, as a tool of aggression. In other words, there's only one legal reason, and that's it, to go to war, and that is self-defense. Self-defense is an inherent right. Israel clearly was exercising on October 8th the right of self-defense. That is to say, Israel was invaded in a very manifest way. There are controversial questions in international about anticipatory self-defense. What if they're about to attack you? This was not an about to be attacked. This is an ongoing attack, an attack that is still going on, not just by Hamas, but by Hezbollah in the north and by other Iranian allies and proxies. So in terms of Israel's decision to resort to war, I think it's very hard to imagine a more justified cause under international law. As for the conduct of war, international law says the following. International law creates a basic rule of distinction that each party is supposed to keep, to make it easy to separate its combatants, people engaged in hostilities, from civilians. And they do that by doing otherwise counterintuitive things like wearing uniforms, which does not actually seem like a good idea if you think about the best way to attack your enemy is not by wearing clearly identifiable, distinctive-looking outfits that make them see that you're coming, right? Much better would be to have bases in civilian homes, wear civilian clothes, and just pick up a rifle, when you see that you have a shot at your enemy. The problem with the latter approach is it's inherently going to put civilians in harm's way, and international law tries to avoid that by requiring parties to distinguish themselves. It's quite clear that Israel does engage in distinction, right? Israeli soldiers wear uniforms, and Hamas does not and hides amongst civilians. It is illegal to put military targets in civilian places. And then international law asks the question: what happens if there is a military target in a civilian place? What if they do use human shields? Mm-hmm. So the answer of international law is quite clear, and I'm referring to the Geneva Conventions and the first additional protocol of the Geneva Conventions. That does not protect the civilian place from being attacked if it's also a military target. So the basic rule: you can only attack military targets, targets of military value. So this could be arms stores, logistics facilities, or actual fighters. Hamas has chosen to locate all of its facilities directly underneath and inside civilian premises, and international law makes it quite clear that that does not get rewarded. Right? You don't get a benefit for shielding your military operations by putting them in civilian premises. That would only encourage you putting civilians more at risk by locating your military facilities there, and completely undermine the basic international law of distinction. So, in fact, it is lawful to target those premises, and the mere fact of civilian casualties is not illegal in international law, because otherwise war would be illegal and self-defense would be illegal. Right? There's never been a war that has not had civilian casualties. America has killed hundreds of thousands and maybe indirectly millions of civilians in its post 9/11 conflicts. Take the campaign against ISIS, right? Tens of thousands of civilians were killed by the U.S.-led coalition trying to get ISIS out of certain cities, and that was not even a war of self-defense by the United States. There has simply never been a war without significant civilian casualties. The war in Gaza is only exceptional in the relatively low number of civilian casualties to combatants, right? That is to say, in the war against ISIS, maybe 13 to 30,000 civilians died to kill a few thousand ISIS fighters. In Israel, the ratio may actually be close to 1-to-1, which is a ratio America has actually never achieved in urban combat. Each of those deaths is, of course, tragic, but that is why we don't like war, right? That's why we try not to have wars. But banning self-defense is not a recipe for not having war. It's just a recipe for massacre by bad actors.
Yeah, I actually saw a statistic on a UN website that said that on average, 90% of those killed in military conflicts are civilians.
Around the world, almost certainly. Now, when the United States, when you look at past United States conflicts, combatant to civilian ratios are said to be 1-to-3, 1-to-4. So something like 25%, 20% would be combatants, and the rest would be civilians. But the ratio is obviously different in Gaza, because Hamas actually seeks to use civilians as human shields. Yeah, but I think we have a lot of questions. Should we get to them?
Yeah. So one on this topic. So and I was going to ask it anyway, so I'll ask an audience member's question. So the UN resolution yesterday, the US abstained from, and therefore it was a Security Council resolution calling for a roughly 2-week ceasefire for the remainder of Ramadan. Is that binding? What is the legal effect of that?
Okay, so let's make a general point, just so people understand where I'm getting this from. Where does the Security Council get its powers from, right? It was not created by God or, interstellar space masters. It was created by the countries of the world in a treaty, the United Nations Charter, right? So under international law, the basic rule is there's national sovereignty, and nothing can bind a country without their agreement. So a country can be bound by a treaty. The United Nations Charter is a treaty. It gives certain powers to the Security Council. It does not give powers to the General Assembly. Those powers it can exercise. What those powers are is it's a very complicated discussion, but it can exercise the powers to make certain binding or let's say mandatory decisions under what's called its Chapter 7 powers. Chapter 7 because it's Chapter 7 of the UN Charter. It can also make Chapter 6 resolutions, which according to the UN Charter, I think Article 36, 37, or thereabouts, are recommendations. So this resolution was not passed under its Title 7 authority. Thus, it was Chapter 7. Thus, it was a Chapter 6 resolution. Chapter 6 resolutions are called by the UN Charter recommendations. So that is its legal status. Is it a binding recommendation? Yes. It all depends what you mean by binding and what you mean. It is a binding recommendation. That is like when you go to a mediator, the mediator issues that is the mediator's recommendation. That's the official recommendation. No joke. Is it are there sanctions? Is it binding in other kind of legal senses? No. So it is the binding recommendation.
Okay, and then what about South Africa's case against Israel in the ICJ? What is the legal status of that?
Oh, I'm sorry. A lot of skipping around. What is the status of that? It's a case in the ICJ. The reason the ICJ has jurisdiction is because a treaty called the Genocide Convention has a provision allowing the ICJ to hear disputes about its application. I don't know. There's a huge amount one can say about this subject. The status is the ICJ had a preliminary hearing. They did not believe that indications of genocide were such that would require them to issue any kind of immediate injunctive measures against Israel.
And what is your, I guess, asking you to handicap it, right? But based on your knowledge of the legal definition of genocide, do you think that case will ultimately prevail?
Those are different questions. It's very hard to know what ultimately prevail means in the ICJ. Those cases can take 3, 5, 7 years to wind out. So the principal impact of that case is its immediate political salience, diplomatic salience, rather than its ultimate resolution.
And how about your view of the legal definition? Do you think
Well, the reason I don't want to answer this is because I think that's like worth a significant discussion. So I do not believe Israel is committing genocide. I believe that conducting a lawful war of self-defense by definition cannot be genocide. You can't have genocide without purposeful targeting of civilians, which Israel is not doing. That is to say, those civilians who have lamentably died were killed in strikes aimed at military targets. But I don't want to sort of give short shrift to genocide. So I don't think it's something we can just deal with on the fly.
Fair enough. Now I am skipping around, but you wanted audience questions, and there is one tangentially related to South Africa, or at least the case, but it's an interesting question. I wasn't aware of this. The question is, it says 2 IDF soldiers, that's Israeli Defense Forces, for those who aren't aware, 2 IDF soldiers who have dual citizenship in Israel and South Africa were informed that if they return to South Africa, they will go straight to prison. My question is South Africa breaking any international laws by doing this?
I don't think they were informed that they would go straight to prison. If I read a news article about this, but if I recall correctly, they were informed that they would be prosecuted for war crimes. I do not, don't believe South Africa has any evidence that they're guilty of war crimes, other than a general belief that Israel's war of self-defense is a war crime, which it's not. But it would not be violating international law by prosecuting its own citizens, because I don't think international law commits countries generally to being liberal democracies. It would be acting, unjustly and violating, basic principles of the rule of law. But you could say more generally, it would be violating various non-binding international instruments about arbitrary detention and lack of rule of law. But it would not be, so it might violate some kind of human rights. But to the extent that they are South African citizens, South Africa does have, authority over them.
Okay.
That does not mean that prosecution would be consistent with international law, or that let me put it this way: Uh, what they're really saying is don't go back to South Africa. You're not going to get a fair trial here.
Right, right. No, because each state can set its own definition of what it considers a war crime, and of course, each state might have its own judicial system, which may or may not have due process, right?
Exactly, exactly.
Okay. Um, okay, another audience question, and again, this is jumping around, but you wanted them, so here we go. Um, you talked previously about the Israeli peace agreement with Jordan.
Mhm.
Um, and a question is, wasn't a part of the Israel-Jordan peace agreement predicated on Israel accepting a Palestinian state in the West Bank?
No. So the basic answer is no. It was an unconditional peace agreement. I believe Article 3 or 4 states that it is without prejudice for the status of the West Bank, which means it does not determine. They're leaving the West Bank for subsequent, to be decided between Israel and the Palestinians. But as far as Israel and Jordan are concerned, there is a state of peace. Once there's a state of peace, whatever the political future of the West Bank is, it cannot be a situation of military occupation, because military occupation only arises in time of when there's a war between countries or a state of war.
And let me ask a follow-up about that then. So I don't remember the exact date, but I believe there was a point where Jordan sort of, I don't know what the legal term is, but it sort of backed off of claims of control or sovereignty over the West Bank and deemed that transfer to either the PLO or the PA. Um, I assume you know what I'm talking about, but probably know the details better than me. What was the history there, and how does that, if it does, legally play into
It
the
doesn't have any
status of the
legal
West
effect
Bank?
because Jordan never had legal claim to the West Bank in the first place. They can't give what they didn't have. Right? They at one point claimed sovereignty over it, and then they disclaimed sovereignty.
And so, historically, for those who don't know, what was the PLO, or how was that created, and what's its relation to the Palestinian Authority?
Okay, I don't have number dates in front of me, so I
That's
don't want to
fine.
say dates. The PLO was I'm gonna skip the PLO question. I just don't want to get details wrong. But the PLO was created in the before 1967. Um, and initially it was opposed to Jordan as well. It is the an part of the PLO, the Fatah faction, is the governing government of the West Bank today. And Abbas is the head of Fatah, which is the leading party in the PLO, and also the governing party of the West Bank.
And you mentioned before that the PA was sort of the government of the West Bank, and that Hamas is the government of Gaza. I've heard it said, though, that Hamas is not a state actor and therefore can't be held to the same standards as a state. Is that an accurate assessment under international
Um,
law?
I don't know why it can't be held to the same standards. I mean, the same standards of what? Right? Of not killing people. I think the standards for being held to the standard of not killing people are very low.
And
It's a governmental actor. And I think we see in many contexts, governmental actors have responsibilities, like in a civil war, for example.
so is so does international law apply to civil wars?
Of course it does. I mean, it applies differently. It's considered as a non-international armed conflict, but it is the case that, you can't kill civilians in a civil war.
That makes sense. That makes sense. Um, uh, okay, let me see. It seems like some of these other audience questions have been effectively answered. I think for some of them, your position would be either they go to the issue of the binding nature of UN resolutions or to sort of the status of states. Let me make sure. All right. Well, I don't know if you want to touch this one within 5 minutes, but um, given the complexities of the Israeli-Palestinian conflict and the divergent legal interpretations, what potential pathways exist within international law to achieve a resolution that addresses the rights and aspirations of both Israelis and Palestinians?
Um, so yeah, the question of solutions. I'm not a, okay. Let's use my methodology here again. So let's take, you have a conflict that's been going on for 70 some years. Take the Indo-Pakistani conflict, right? Or, another very long conflict, the Cypriot-Turkish conflict. Let's use international law to solve it. If it were that simple, it would be solved already, right? So international law, some people think has this like promise of solving things. The reason these things are unsolved is because you have two fundamentally divergent interests where there's no overlapping bargaining range. And, on multiple occasions, the parties came together and made a bargain, and Israel's best offer was not a good enough, which included full independent statehood, was not good enough for the Palestinians. I have an article in the Wall Street Journal I would refer you to called Take the Palestinians No for an Answer. The Palestinians are the only national independence movement I know that has been offered full internationally recognized statehood and have turned it down. And indeed, they've done so not once, but more than once. So I don't think international law is necessarily going to provide significant solutions any more than we think international law is going to solve the Chinese-Taiwanese conflict, the Russo-Japanese border dispute, or any other, dispute that has been simmering since the 1940s.
Well, I appreciate that. I realize I've been asking some very massive questions, which probably any one of them could be worth an entire semester's worth of course. And I'm asking you to sort of on one foot answer these questions in a few minutes. So I appreciate you bearing with me. I also think one of the most important things I've learned from this discussion, right, is I think the point about methodology, right? And I think methodology is something that we as law professors value because there is value in it, right? I think the point of when you're looking at the the Israeli-Arab conflict, stepping back and saying, what are first principles, right? What are generally applicable principles of international law? How do they apply broadly across the board? And then say, and how is that applied to this particular conflict? I think that's a really important takeaway. I think it's also important, as your last answer just emphasized, is the limits of international law and what it can do. Generally, the territory of the world is divided up in sovereign states, and usually that is the highest level of authority that there is within that territorial boundary. And whatever authority exists between states is limited to whatever they've agreed to. And it sounds like, based on the League of Nations, the UN, the Geneva Convention, right, that there's only so much that states have ceded to an international body to make decisions on their behalf. And so because there's not a lot of law out there, so to speak, to a large extent.
Lawmaking institutions, which is probably a good thing because one would not want to turn power over countries over to lawmaking institutions, dominated by China, Russia, and Venezuela.
Right, which is also a very good and very important point. So, look, there's a reason why this, as you said, this conflict's been going on for many, many decades. If it was easy to solve, it would have been solved. I wish I had the answers, but I don't. But nevertheless, I think seeing this distinction between what international law provides and what really is just a matter of politics or power is an important distinction. I think you've done a great job, very eloquently delineating those limits. And so I want to thank you for bearing with me. I know, like I said, I jumped around a lot, tried to cover a lot in a very short amount of time, but I appreciate perspective. I appreciate those in the audience who took time out of your day to tune in and hear about these very big but very important subjects. And I want to thank everybody behind the scenes who made this webinar possible. So
thank you for having me
on behalf of Purdue Global Law School. Wait, sorry, what?
Thank you for having me, and I want to thank everyone for their attention.
Yeah, thank you. And I look forward to seeing you all at our next Student Speaker webinar. So take care, everybody.